Well, I can't say it happens in every mediation, but it happens in a lot of them, maybe even in most. It's that point of the mediation toward the end of the day where the plaintiff is just not happy with the amount of the offer that's on the table, but doesn't yet want to walk away from the negotiations. And yet the defendant is just tapped out. They've gone as far as they can go. They've done all they can do. Well, having mediated several hundred cases over the last decade, I have often found that two words, two concepts, used at the right time with the plaintiff may be enough for he or she to consider that offer and the additional value that comes over and above the monetary settlement offer. And those two concepts, those two words, are closure and certainty. Closure, the case can be put behind them. They can move on with their lives. Certainty, they know what they're going to get, as opposed to the uncertain results that might occur if they move forward with the litigation and go on to trial. Now, only the plaintiff can put a value on those two factors, those two concepts. But yet the plaintiff needs to be reminded, again at the right time, that those two things do in fact have value over and above the monetary settlement. There is one occasion, though, that the word closure ought not to be mentioned. I got this from Rob Perkison, who is a great mediator. He's probably done 2,000 mediations. He gave a seminar back earlier this year in Greensboro. And in that one occasion, that one type of case that closure should not be mentioned to the plaintiffs, is in a wrongful death action. There is no closure for the survivors of a loved one who has been killed. The litigation may be over, but there's still no closure. He said he made that mistake once and he's learned by it, and I appreciate him sharing that. But with that one exception, you may find, if you're a defense attorney, to suggest to the mediator to use those two words. If you're the plaintiff's attorney and don't want to talk about those with your own client, maybe suggest to the mediator to talk about that with the plaintiff. And of course, if you're a mediator, I suggest those two concepts to you, and I hope they will work well. Good luck with your negotiating.